Evictions are filed every single day throughout the state of Texas, throughout the US. The question for you is, what secrets are out there that you can use right now to make a better choice when it comes to your eviction? Today we're talking all about the secrets to winning your eviction. Let's get started. If you watched enough of my videos, it's pretty plain that what I'm going to instruct you to do is basically to be more prepared than the other guy. It comes just as simple as that. If you can be more prepared than your opponent, you are likelier to prevail. Now, when it comes to landlords being better prepared, there's nothing better for you, especially if you've never been to an eviction before, than to go and watch an eviction. Now, you can do that at the day of your own trial, but you might be first and have nothing to see ahead of you. So what I suggest to landlords is pretty simple. If you've got an upcoming trial, or you're thinking about filing an eviction, or you're in the middle of your first lease and you think, you know what, it might help for me to get prepared before I ever need this knowledge, I strongly recommend that you visit the justice court in your area where evictions are held and take a seat in the gallery and hear the kinds of things that landlords and tenants say to judges and the kinds of responses they get from judges. You're going to have a wealth of knowledge right in front of you, absolutely free, where you can learn from other people's mistakes. You can also see the kinds of things that win eviction cases. You can see it firsthand and hear it directly from the court. Make sure you stay all the way to the end, because the last secret I'm going to share with you, 99% of you are going to get wrong, even after you've watched this video. Especially if you're brand new to the eviction game, it's important for you to get a mentor or a friend, somebody preferably who's done this thing 10 times more than you have. I often recommend to landlords, if you own one rent house, find somebody who's got 10 of them, because their knowledge is going to be extremely helpful for you. And if you've never gone to the eviction court, find somebody who's done it at least 10 times for that very same reason. That multiplier means that they've probably got years of experience ahead of you, and they can share insights, especially if you're in the same rental market. They can share insights with you that you really can't get anywhere else. If you want to be better prepared than your opponent in an eviction, make sure you are extremely familiar with your lease. You don't want to be in the middle of a trial and have the court ask you about a specific provision or a specific term or a specific deadline found in your lease, and you just don't know where it is. Too many landlords sometimes shoot themselves in the foot by not knowing the content of their own lease. Know what your provisions say, know what your own obligations are, and know what you can demand of your tenant in an eviction. By being super familiar with your lease, by knowing it better than your opponent, you're likelier to win in the eviction court. If you want to prevail at your eviction the very first time you file it and don't have to file over and over and over because you've made so many mistakes, make sure the one thing you absolutely do is keep excellent records. Among all of these things, one of the things that trips up landlords the most is failing to prove the claims they're making in their lawsuits, because they simply show up without any records whatsoever, but their opponent has shown up with records. I've seen it over and over where a landlord shows up with nothing, but a tenant shows up with receipts, with money order stubs, with canceled checks, and says, "Your Honor, I've made payment." Now, whether this is true or not is maybe a different story, but if you can't prove what is true and they've brought believable evidence, you're going to be in a tough spot and you're probably not going to win your eviction. One thing that gets a lot of new landlords is their notice to vacate. So if you want to ensure that you have a winning eviction, you need to know how to perfect your notice to vacate. And perfection includes not just the substance of the notice, but also the delivery. Do you know what your jurisdiction requires in the letter itself? What kinds of things do you need to inform your tenant of in the notice itself to make sure you've got a rock solid notice to vacate? And finally, the delivery of it. What do you need to do in order to demonstrate to the court not only that the notice itself is substantively correct, but that you turned it over to your tenant in a way that's acceptable in your jurisdiction? In my office, we send everything through regular and certified mail because we know that sending something by regular and certified mail allows us to track both letters as they travel simultaneously to the tenant. And even if that tenant never picks up the certified letter, we know from the USPS records when the letter carrier first attempted to deliver that notice to vacate. And because both letters were sent simultaneously, we know that when the first attempt was made to deliver the certified letter, that regular letter that we mailed at the exact same time definitely got delivered on that day. And by tracking our letters this way, we're able to demonstrate to the court with precision when the notice was delivered. Additionally, we line all of our notices completely up with the property code in the state of Texas so that we're certain that not only delivery was perfected, but that the substance in our notice is perfect every single time. We identify each of the tenants listed in that lease who signed their names to that document, and we notify them of each of the claims in our intended eviction petition. By being extremely clear and by knowing precisely when that notice was delivered, we're able to present a case that wins in the eviction court. You want to make sure that you are filing every possible claim that you have. You don't want to be left out in the cold wishing, oh, if only I had mentioned this and this and this. Because sometimes you show up to the court and you get beat. Your opponent has better evidence than you do, or the judge simply doesn't buy your claim. And so why keep 3 or 4 claims in your back pocket? If you've got them, you ought to use them. So if you've got non-payment of rent, but you also have an unauthorized occupant, maybe unauthorized pets, maybe damage to the property, and all of these are viable claims against your tenant, if your tenant shows up and presents a believable justification for non-payment, which there really aren't many, but if they do, guess what? Now they have to provide believable evidence against all other claims. And if they simply can't do that, you really only need to win on one of these claims in order to recover possession. So don't hold back any claims that you have. If you have valid claims, present them. The court may say, look, all I needed to hear was you had non-payment of rent and you won the case. But what you don't want to hear is, well, if only you had pled these additional claims, I would have granted your eviction judgment. If you've got them, use them. If the court says you don't need them at the time of trial, no big deal, but you certainly don't want to be left out in the cold wishing you had filed correctly. Landlords, if you have found this video helpful, I ask that you give us a big thumbs up. Any questions or comments, leave those below. I answer those myself. And if you're not yet a subscriber, please consider subscribing. We really appreciate that. And finally, that secret that everybody forgets. 99% of you are just going to overlook this very basic principle. If you want to be successful in your eviction, you need to learn to keep everything in writing. If you deviate from this, you're likely going to say something or do something that jeopardizes your position in the court. Sometimes as simple as accepting money after you've sent your notice to vacate can wreck your eviction. But if you handle everything in writing, you're likelier to be successful. So that it is crystal clear the money you accepted left a balance that is still owed, and that your intention is to continue to seek the eviction unless everything is paid. By being crystal clear and keeping your message completely in a written form, you can demonstrate to the court precisely what was agreed to between you and your tenant. And when your tenant tries to state something outside of that written agreement, you can say, no, Your Honor, all of our correspondence was in writing. Everything we discussed is right here in black and white, and nothing else exists. By preserving a clean record, you are likelier to be successful, and you can prevent your tenant from misconstruing or misunderstanding, or worse, misrepresenting the discussions you had leading up to your eviction. By taking that right off the table, you're going to ensure success when you present your case in the eviction court. Landlords, evictions can be complicated, but I'm here to make them less complicated for you. If you enjoyed what you saw today, I welcome you to watch the rest of our content. YouTube seems to think that this video right here is the next best thing for you. I welcome you to watch all of the other videos on this channel. But until next time, happy leasing.